दोस्तों नमस्कार। आज हम देखेंगे क्या पॉसिबल है कि जो व्यक्ति रिटायर हो जाता है उसके बाद में उसके खिलाफ में डिपार्टमेंटल प्रोसीडिंग या डिपार्टमेंटल इंक्वायरी ली जा सकती है और इसके ऊपर कानून क्या कहता है। दोस्तों, डिपार्टमेंटल इंक्वायरी आफ्टर द रिटायरमेंट, ये जो कंसेप्ट है, इस सिलसिले में हमें जो प्रोविजंस को देखना है वो नॉर्मली सीसीए रूल्स में इसके प्रावधान नहीं मिलेंगे, या सिमिलरली महाराष्ट्र गवर्नमेंट के जो एमसीएस डिसिप्लिन एंड अपील रूल्स है उसमें प्रावधान नहीं मिलेंगे। तो हमें देखना पड़ेगा सीसीएस पेंशन रूल्स, सेंट्रल सिविल सर्विस पेंशन रूल्स, सिमिलरली महाराष्ट्र सिविल सर्विस पेंशन रूल्स। तो पेंशन रूल्स में ही प्रावधान आते हैं जो जिसके तहत डिपार्टमेंटल इंक्वायरी अगेंस्ट रिटायर्ड एम्प्लॉय पॉसिबल है, लेकिन उसमें कुछ प्रावधान है जो कि फॉलो करने बहुत जरूरी है। तो जैसा कि मैं आपको कह दूं, सेंट्रल सिविल सर्विस रूल्स पेंशन रूल्स के नियम 9 यानी कि रूल 9 ऑफ सीसीएस पेंशन रूल्स, सिमिलरली महाराष्ट्र सिविल सर्विस रूल्स पेंशन रूल्स के नियम 27 यानी कि 27। तो ये जो दो रूल्स है ये आप ध्यान में रखिए। वर्बटिम कॉपी है या उसमें एक अंतर जो है, सेंट्रल सिविल सर्विस रूल्स पेंशन रूल्स में जो रूल 9 है वो प्रेसिडेंट को रेफर करता है, तो महाराष्ट्र का जो एमसीएस पेंशन रूल्स नियम 27 जो है वो रेफर करता है गवर्नमेंट ऑफ महाराष्ट्र को। इतना ही फर्क है, बाकी सब एग्जैक्टली सेम प्रावधान दोनों में पाए जाते हैं। तो सबसे पहले तो मैं आपको ये बात बता दूं कि रिटायर्ड एम्प्लॉय के खिलाफ में इंक्वायरी अगर लेना हो तो वह इंक्वायरी का जो सब्जेक्ट होता है, जो मिसकंडक्ट होता है, वह ज्यादा से ज्यादा पिछले 4 सालों के अंदर ही होना चाहिए। यानी कि रिटायर्ड एम्प्लॉय के हाथों से कुछ मिसकंडक्ट हुई हो, लेकिन जिस तारीख को उस व्यक्ति के खिलाफ में इंक्वायरी का इनिशिएशन होता है उस तारीख से पिछले 4 साल इमीडिएटली प्रीसीडिंग 4 साल के अंदर ही अगर मिसकंडक्ट है तभी जो है उस व्यक्ति के खिलाफ में इंक्वायरी पॉसिबल है। नंबर 1। नंबर 2, ऐसी इंक्वायरी प्रोसीडिंग जो है वो इनके सब सेंट्रल गवर्नमेंट एम्प्लॉय अगर आप है तो प्रेसिडेंट ऑफ इंडिया के प्रायर सैंक्शन के बिना यह इंक्वायरी पॉसिबल ही नहीं है, क्योंकि रूल 9 सीसीएस पेंशन रूल का रूल 9 स्पष्ट कहता है कि ऐसी इंक्वायरी अगर शुरू करनी हो तो प्रायर परमिशन, प्रायर सैंक्शन ऑफ द प्रेसिडेंट ऑफ इंडिया इज मस्ट। तो यहाँ पर दो बातें सामने आती है। सिमिलरली महाराष्ट्र गवर्नमेंट का एम्प्लॉय अगर हो तब भी जो है यही रूल लागू होता है। इंक्वायरी उसी मिसकंडक्ट के लिए ली जा सकती है जो मिसकंडक्ट जिस दिन आपको चार्जशीट दिए जा रही है या जिस दिन आपके खिलाफ में इंक्वायरी का शुरुआत हो रहा है उस दिन से लेकर पिछले 4 साल के अंदर ही मिसकंडक्ट है तो ही आपको वो चार्जशीट दी जा सकती है लीगली। दूसरी बात, अगर आप स्टेट गवर्नमेंट के एम्प्लॉय हो तो आपको स्टेट गवर्नमेंट के जो यानी कि गवर्नर होते हैं उनका प्रायर सैंक्शन होना बहुत जरूरी होता है। सेंट्रल गवर्नमेंट के एम्प्लॉय हो तो प्रेसिडेंट ऑफ इंडिया के सैंक्शन, प्रायर सैंक्शन होना बहुत जरूरी होता है। तो ये दो बातें। नंबर 1, that the inquiry against retired employee cannot be initiated except with the prior sanction of the President of India in case of the state, except with the government of the state government in short। ये बात। नंबर 2, the inquiry cannot be with regard to the incident or the misconduct that goes beyond preceding 4 years from the date of the actual charge sheet। For example, if I have retired on 31st December 2020 and in the year, that is very next day after my retirement, let us take very next day, 1st January 2021, if I am being charge sheeted then my misconduct must be within immediately preceding 4 years, यानी कि 20, 19, 18 and 17, यानी कि that must be within this 4 year. If the misconduct is committed by me in the year 15, 14, 13, which goes beyond 4 years, therefore in such case there is no possibility, there is no provision which authorizes the government or permits the government to hold the departmental inquiry. Similar provision is also in Maharashtra Civil Service Rules, Pension Rules. Now, ऐसा possibility होता है कि you are already charge sheeted when you are in the service, and then inquiry goes on. During the pendency of the inquiry, you retire. Then what is the provision? Then also these rules say that in such case, the inquiry which is initiated when you are in service shall continue, and then the only difference with this case is that when you are in service, the penalty could be major penalty of dismissal from service, removal from service, or any other penalty. But after you stand retired, it is not possible to impose the order like dismissal or removal from service. Therefore, in such case, the penalty would be different. What would be that penalty? Is that these rules authorize or permit the government to deduct the pension either in part or in full. So the penalty would be deduction of pension either fully or partly. So these are the provisions with regard to the inquiry against the retired employee. Suppose there is no such provision in case of the public undertaking and the employee stands retired, and there is no such rule which is analogous to rule either pension rule, CCS pension rule 9 or Maharashtra Civil Service Rule 27, then in that case the inquiry cannot be initiated against the retired employee. That means, in short, there must be such provision of law which authorizes or empowers the government to hold the inquiry against retired employee, number one. Number two, these provisions will have to be strictly followed. That means the inquiry has to be only for the misconduct which happens within immediately preceding 4 years. Thirdly, it has to be with the prior sanction of the president or the state government, as the case may be. And in case of public undertakings, there is similar provision, and this power may be given to the highest body, that is highest authority, which normally happens to be the CMD, that is Chairman and Managing Director. So these are the provisions with regard to the holding of departmental inquiry against the retired employees. Moreover, in such cases, the penalty cannot be like dismissal or removal or reduction into rank or compulsory retirement, because already you retired. So in such cases, the penalty would be only deducting the pension or deducting the pension either fully or in part. Again, there is a rider that before the pension is deducted either fully or in partly, in case of the central government, it is necessary that the UPSC has to be consulted. In case of the state, MPSC has to be consulted. That means the Union Public Service Commission has to be consulted in case of the central government employee before the pension is cut or deducted as a penalty after the inquiry is over and the guilt is proved. In case of the state, the Maharashtra Public Service Commission has to be consulted before the penalty of cut of the pension or the reduction in the pension partly or fully is imposed. So these are the provisions with regard to holding the departmental inquiries. Now the difficulty in such cases is that when such inquiry is initiated, when you are in service and you stand retired, it has got very dangerous effect on your payment of gratuity, because rule 30 of Maharashtra Civil Service Pension Rules directs that when an employee is subjected to the departmental inquiry and he retires when the inquiry is pending, then payment of gratuity shall not be made. That means the employee has to wait till the final outcome of the inquiry. Similar provision also lies in Central Civil Service Rules, Pension Rules. Therefore, the inquiry against the retired employee or the continuation of the inquiry against the retired employee has got drastic effect on the payment of gratuity. Now let me tell you, in case the inquiry is initiated after you stand retired, then maybe then next day after your retirement. In that case, the gratuity cannot be withheld. Gratuity is to be withheld only when the inquiry was initiated when you are in service and then you retire, pending the inquiry. So these are the minor things which have to be kept in mind. Now there are some cases where you know inquiry was held against retired employee and the punishment like dismissal was imposed with effect from the back date, that is retrospective date. Whether this is possible, so Supreme Court has given a verdict in the case of A.R. Kulkarni versus State of Maharashtra that it is not possible because no penalty of dismissal can be imposed upon a person who is already retired, and that too with retrospective effect. So this is the law. This judgment of A.R. Kulkarni versus State of Maharashtra is of larger bench, that is a three-judge bench of Supreme Court. Therefore, it is very valid law. On these lines, you will find several different yeah, cases like R.R. Mittal versus Ecobank, CMD Ecobank, etc. Uh, Now, let me tell you finally that even after the end of the departmental inquiry against the retired employee, say guilt is proved and it is decided that 5% of the pension is to be deducted or 10% of the pension is to be deducted, because it is not necessary that the entire pension has to be deducted as a punishment. Depending upon the gravity, depending upon the misconduct, the pension amount which is to be deducted is decided. So 5% or 10% pension is to be deducted as a penalty, then it will have no effect on the payment of gratuity. Gratuity has to be given. But because of the pendency of the proceeding for long time, and generally we see that inquiries are not over within short time, they take sometimes years together even after retirement, and we do have such cases at our hand in the courts, that the inquiries initiated when the employee is in service continue for the years together after the employee stands retired, and in the meanwhile he is deprived of the gratuity. At the end of the inquiry, only 5% or 10% of the pension is deducted or cut, and then the gratuity has to be given fully. But this provision, which says that the gratuity shall not be paid as long as the inquiry is not concluded, is very draconian kind of provision. It has to be uh, removed from the statute book. Now, again, one aspect that we must keep in mind, that the inquiry against the retired employee has to be only with regard to the misconduct which is of gross negligence or the grave misconduct which has caused the you know damage, which has caused damage to the property of the uh, employer in case of the gross negligence or the grave misconduct. That means if the misconduct is minor of very uh, trivial nature, then in that case also the departmental inquiry against retired employee is not permissible or is not legal. So these are the important aspects with regard to holding of departmental inquiries against the retired employees. In this regard, it generally happens that the penalties which are not prescribed by law are also imposed after the retirement. I had one such case. Let me explain that case. One inspector from Mumbai was subjected to departmental inquiry before he was retired, and then before the retirement, maybe within a before a month of his retirement, the inquiry got over and it came to impose the penalty. And ultimately, it was decided to impose a minor penalty, not penalty like dismissal or removal from service. Then the authority devised a new penalty which was not given in the Mumbai police rules, punishment and appeal rules. So penalty was of such a nature that if at all had he continued in the service, then he would have been subjected to loss of so and so rupees. The amount equal to such loss would be penalty upon him, and that amount will be deducted from his salary till he retires. So that kind of new penalty was devised and that was imposed. But then we challenge the same on the ground that Mumbai police rules, punishment and appeal rules do not prescribe or provide any such penalty, and on this ground alone, the tribunal has set aside and quashed the penalty, because this is very interesting issue, because Article 20 of Indian Constitution comes into play. Article 20 declares that no person shall be punished with the penalty greater than the penalty which is provided in the law. That means penalty has to be prescribed in the law. If the penalty is not prescribed in the law and that penalty is imposed by inventing, then it is absolutely illegal. And it is not only illegal, it goes to violate Article 20 and Article 14, Article 21 also, because in other cases, the other people who are also held guilty of the misconduct are not being punished with such penalty. So these kind of things are also very vital, that even the entire inquiry proceeding is vitiated when the penalty is such penalty which is invented by the authority and which is not prescribed in the law. So these are all aspects which are uh, uh, necessary to be kept in mind when we deal with the departmental inquiries with the retired employees. So dear friends, I stop here. Thank you.